look, I've dealt with this so many times, and also personally, because we've moved, multiple times to new school systems. Let me go ahead and tell you this, and I love to say this. I'm not saying I coined it, but maybe I did. I don't know. But there is no get to know you clause in the IDEA. All right? The law does not have a get to know you period. All right? You transferred in. This is a federal law that applies to all states and territories, and to where the states have to replicate at least the federal law, and if they want to, they can enhance it. All right? You say you're in Arkansas. Okay. So at that point, Arkansas more than likely is one of those states that just follows the requirements of the federal law. So on a federal law level, you transferred from a state with an IEP, and they're required from day one to take that transfer IEP that you moved in with and provide comparable services to what that IEP that you transferred in dictates. Okay, so accommodation, supports, the goals, the services, all of it in a comparable fashion. Now, on a comparable level, what does that mean? Well, exactly what that means. It doesn't mean exact. It means that, because sometimes some of these IEPs that come in, they're not 100% replicable, but you can do comparable. So depending on what's in there. And to sit there and tell you, well, we have 30 days. No, they don't. You have 1 day. And, at the same time, let me go ahead and tell you, is it a violation on day one if they're not following your child's IEP? Yes and no. Yes, on a level, but no, there's no punishment for not following it. Because whether your child made progress is dictated over the course of the school year, or in your case, for the remaining of the portion of the implementation dates of that IEP. And so if you see your child's anxiety rising, and if you see problems occurring, then see, that's very, very disconcerting, and that is going to be a problem for the school district, because if they do not implement what has worked for your child in their prior location, then what that is going to do is spiral your son, which is what you don't want to happen. And then at that point, you got regression. At that point, you've got problems. And at that point, you have a good due process case to sit there and slap your new school district for failing to comply with the comparable dictates and demands of your child's transfer IEP, which I've had many of cases like that. They're just not that difficult to prove. Why? Because you have a transfer IEP. They have nothing. This is what's on display. They have nothing, because they're still getting into the process. Depending on the state, some states require that they have to evaluate your child. So, before they can create their own Arkansas IEP that would be applicable to him. So we're dealing with your transfer IEP alone. And if they're not implementing it, and if you can sit there and show that your child is not thriving, progressing, because, it's progressing. Thriving is a higher standard, but your child's progressing. So if there's issues to where your child is starting to spiral out, then make sure that you are notating that in whichever way you can notate it, either in emails to staff, maybe they're sending notes home, but you need to sit there and cover your bases. I know you don't want to be confrontational and you don't want to be that mom, but look, let me just tell you, I don't know, depending on the school system, I don't know if any parent ever truly gets away from being that parent. All right, there's such a crazy definition of what that would be, at this school as opposed to this school district, and different from this school and then the neighboring school 2 miles away. So yeah, if you're advocating for your child, then at that point, I'm sorry, you're always that parent. But I get what you're saying. You want to maintain a good working relationship with your IEP team. But they're not really letting you do that right now, are you? Are they? So what you don't need to do is you don't need to sit there and absorb the guilt that should be theirs. Because they have your child's plan, and if you are proactive in providing that, and if you are proactive in asking for these supports to be in place, and then the principal at least is being honest and saying, oh yeah, they're not doing it. Well, if they're not doing it, then what do we need to do to make sure that it's being done? And see, that's your next step. They admitted they weren't doing it. So what's the next step in making sure that it's being done? Because, I mean, the reality, even though I said that there's not a get to know you clause, that's true. There is no get to know you clause. They have this plan, and it should have been designed in enough detail to where this different school can implement it without hiccups, or with the least amount of hiccups. Now, what is the reality? They don't know your son. So at that point, you know, not that changes anything. It doesn't legally. But the reality is that they probably need another IEP meeting. More discussion needs to be had. But I will tell you, if your special education director's out of town, that's too bad. Yeah, that's who you need to go to. And if you're uncomfortable with making it appear that you're going over the head of the principal, let me just go ahead and put your little mind to rest on this. The principal isn't in charge. Principal is in charge of that school. The special education director is in charge of all of the IEPs. And at the end of the day, when I file a complaint, I'm not dealing with principal because principal has no power. Principal cannot settle with me. This is, in the world of James Galini and practicing special education law, the principals are down here. I don't deal with them. Very rarely, even though they trigger most of my problems, they're down here in the hierarchy. Who settles with me? Who negotiates with me? Who commits resources for my client? The special education director and the superintendent. Not even the Board of Education. The Board of Education just rubber stamps what these two agree to. All right? Principals are down here. They're but yet they cause a lot of my problems because of a lack of understanding. So you're not going over this person's head. Now, to sit there and show respect so that the principal who needs to understand what's going on in his or her school, I do think that in your emails and your communications, you need to include the principal out of respect. You know, you can do that. So any emails you draft include the principal. But please understand the real hierarchy. Even though the school may not look at it that way, the true structure with regards to the area of law that I navigate, the reality is the principals are down here. And the director and the superintendent are up here, and that's who I deal with. And because they're the real decision makers. They're the real problem solvers. And in your particular situation, that's who can solve this problem in the least amount of time. Because they would have the resources to be able to bring in, let's say, a psychologist, the proper counselor, if your child, has that need, a board certified behavior analyst, depending on the nature of your child's disability, to bring in some outside assistance to sit there and train staff on these accommodations and on your child's plan. They would help start and catch everybody up as to your child's needs. And that's what I would be pushing for, is an outside hat that has an expertise in behavior, anxiety, and then how to properly implement those things so that they can pass on that expertise to the staff. And I would require it to be competency-based or fidelity-based training of the staff on your child's behavior and anxiety needs, okay? But, don't ever be I'm going to shut up about that. I can't tell other people not to stop being them. I mean, and I understand not wanting to be confrontational. You don't need to change, okay? But you can be diplomatic in your request and include the right people in this dialogue. Because if they don't get this handled, then it would put you in a position to have to step in and trigger one of the dispute resolution options like due process in order to protect your child.